Any questions for Representative Butler?
So let me see if I understand that. So if I have a certified document that I've gotten maybe presumably from another court or another jurisdiction and I want to record it, is that what you're saying? I don't have to match the standards?
Correct.
Because I can't really? I mean, if I
Correct.
get it from another place? Okay.
Certified court-filed document.
Do I have to pay the $25 non-standard fee? If I,
It's exempt, so I wouldn't think you'd have to pay
yeah.
a non-standard
Okay.
fee.
All right. Thank you.
Yes, ma'am. Any further questions? Do we have a motion? Representative Smith?
I move for a favorable report to Senate Bill 445 with a referral to rules.
Heard the motion, all in favor? Aye. All opposed? The bill passes.
Okay.
What do you want to do next?
We can do 1070, which is Representative Bradford.
House Bill 1070, Representative Bradford.
There's a PCS. Is it
Uh,
PCS? Yes.
I'm sorry, there is a PCS before the committee without objection.
Oh, okay.
Representative Bradford.
Thank you, Mr. Chairman, members of the committee. I want to thank Representatives Kyle Hall, Biggs, and Cunningham for being on this bill with me. House Bill 1070, there's a PCS before you. Basically, this is just some property rights and protection issues. The summary, I'll be quick with it. Basically, will make sure the small claims appeal period starts when a judgment is actually digitally is rendered, meaning versus when it's entered by the clerk. So when it's actually rendered by the magistrate, that's when a shot clock would sort of start in terms of an appeal period. It requires written findings of indigency in small claims, so people still have the right to claim that they're indigent, but it just clarifies, how that process goes. It allows a magistrate or a superior clerk judge to actually compel a bond payment to be released within 5 days. Some of the clerks are running behind, which we understand, but if a magistrate or a judge actually makes the order and says it needs to be compelled within 5 days, then it would get done sooner. And that would be, of course, at the will of court. We're increasing punishments for willful and wanton damage to residential real property. This could be squatters that have taken possession of a property that maybe do terrible things to the house. Pouring concrete down toilets, for example, drycrete, and then it sets. I mean, they're just some real egregious things that sometimes happen. So this increases punishment for those things if it's willful and wanton, and then prohibits fraudulent rental, lease, or advertisement for sale of residential real property. So this happens a lot today on Craigslist. People will take photos of a property that's not theirs. They will advertise it as their own. They'll make it a sweet deal. Some unsuspecting person comes along, doesn't do their diligence. Next thing you know, it was never their property to lease, and so we're going to put, make that obviously fraudulent and put some crimes there. I have worked with every stakeholder that I'm aware of. So the North Carolina Apartment Association supports this bill, the North Carolina Association of Realtors, the North Carolina Rental Home Council, the North Carolina Justice Center. They had concerns. I addressed all of them. Someone is here to even speak on that. So just, they're at peace, if you will. And even AOC is A-OK because they can't, weigh in on policy. Representative Cunningham, any comments on the indigent, since I know.
Thank you, Representative Bradford. So we had run into an issue on the declaring of being indigent. When you go into the courts in some areas, they just sign off. There's no proof required that they provide that they're indigent. And so lots of individuals that are renting, once the judgment come in from the court, no matter what amount it is, they can go back again and state that they're indigent, and therefore the judgment is wiped out. I absolutely support the bill and work with Representative Bradford and others and all of the other entities that he mentioned. So I ask for support for the bill. Thank you.
Do we have any questions from committee? Representative Butler?
Yeah, in large part, I think the bill is okay. And given the litany of folks you said who are on board with it, I was wondering about the Association of Clerks, because I bet they're not on board with it.
Well,
Because they have to pay penalties and fines.
No. That's you're looking at the PCS takes that out.
Okay.
So
All right.
I was worried. I was never trying to penalize the clerks. We were just
Okay.
trying to incentivize them to do it quicker. So instead, by going through having a magistrate or superior clerk judge compel the bond to be paid, that removes that.
Okay, thank you for that.
You're very welcome.
Representative Bud?
Yes, generally speaking, I think the bill is good. I did have a question with regards to the small claims court judgments and when they are rendered. Small claims is not a court of record, which means that the proceedings are not recorded as they go through the process. And oftentimes, especially in Mecklenburg County and our other larger counties, the judgment is rendered by the magistrate, i.e. Given orally in court, and they make a note to the file, but they don't fill out and sign the orders at that time. Sometimes it will take 2 or 3 days for the order to be signed. Then it has to be entered by the clerk into the system. Given that the appeals process out of small claims is only 10 days and the way this is written, my concern is that rendered does not do what you're intending it to do, which I think is when the judgment is signed, that the 10-day clock starts then for the appeal. But you have to remember in small claims, by the way it's structured, litigants, including landlords, don't always get a copy of the judgment the day they're in court. Sometimes you have to go back and get it several days later, by which point we might have run the appeal clock out. So I wondered if you had a response to that or some proposed revisions to clarify that.
May I? Yeah, so again, working with a variety of stakeholders here, not an attorney, I just play one here. What I would say is that this section sort of defines what rendered means. So it would authorize judgment, small claims action to be rendered electronically. So that's with the new e-filing system. So electronic notification is more instantaneous than anything. So that's described. And then section 1B talks about would amend provisions prescribing the start time for the appeal period on small claims action to refer to the time when a judgment is rendered rather than the time when a judgment is entered. So I think the language makes it clear. I hear your points, but the reality is what's happening. And so I think this is a statutory issue versus a practical one. Today, what's happening is the clerks have such voluminous work that maybe by the time they actually get into entering it, so much time has passed, and you have someone who's in this property that isn't paying, it's hurting the landlords, honestly. And so this is not taking away any appeal rights. This is just clarifying the shot clock. And I'm very comfortable with what we have because I've worked with so many groups to get it. Anyway, I hope that helps.
Follow up.
So several years ago, the small claims amount went from $5,000 to $10,000. So a number of attorneys like myself suddenly found themselves in small claims court for clients because it was more efficient. And I will tell you that the 4 corners of the document, the way that it is written, where it says the rendered electronically is fine because that's going to be your file stamp date, but the written and signed is the problematic piece. So I think what I would recommend is a revision, an amendment to it that says written, signed, and entered electronically, because that is very clear, because it means it's got to be written, signed, and entered electronically, which is what the new system is. And for those counties who are not yet on board with the e-courts, they'll soon catch up.
Yeah, I appreciate the feedback. I'm not prepared to support what you're saying yet. I mean, we can work on this outside and get these groups involved, but right now, I just appreciate the vote as is. Thank you.
Any further questions? Representative Stevens?
I just want to respond that I did hear from AOC, and they did indicate a lot of the problem was Mecklenburg County. And they asked for this effective date to be delayed a little bit so they could work with Mecklenburg County to get it right. I know of no reason, because the orders are form, why a magistrate doesn't sign one and submit it that day. And the clerks are frequently held responsible for what the magistrate does. If they don't turn their money in on time, it's the clerk's fault, not the magistrate's. So some of those are trying to make the magistrates more responsible, and I think AOC's gotten the message and indicated they're going to work on it.
I'm sorry. Any further questions? Representative Moore?
Thank you. And I think your purpose, I think Representative Budd pointed it out. I think you have a problem with what you're now calling rendered versus entry of judgment. E-courts may help with that, and I think what Representative Stevens said, maybe what you need in the language is as soon as it is announced, signed, entered in court, that is your day. It's not entry of judgment. That may be a few days later and defeats the purpose of having the judgment right away. So I think there could be something tightening up to get right to your purpose about the rendering and the entry of judgment. The only section I have a question about, which I usually do and I always kind of go against, is raising the property damage to a Class I felony if it's damaged at more than $500 or more, which I think is inconsistent with other provisions of our criminal code of $500 being misdemeanors. It would be $1,000 to go up to a felony, would be consistent with like larceny, felony amounts versus misdemeanor amounts. So I would ask that you consider changing that results in damages valued $1,000 or more to take it up to a Class I felony.
Yes, good.
Thank you for all the recommendations, but I would ask at this time that we will go ahead and move the bill. Representative Bradford and I have been working on this over a year with all the entities involved. If anything else comes about with statutory that needs to be changed, I'm sure that we can do it. But right now, we need to move.
Yeah, Mayor. Last comments. I mean, willful and wanton's a higher standard to prove anyway, but all I'll tell you is I've been known to try to work with anybody and everybody to an extent. So I'm happy to tighten up anything where we can. I just have been working with a lot of folks, and so all these things you're raising, Representative Budd, Representative Morey, if these other groups and I and us can tighten it up, so be it. Time is not our friend here, so we're trying to keep this baby moving. Thank you.
Any further questions, Representative Smith? You're recognized.
A comment and then a motion.
Yes, sir.
I just like to say, I'm certainly going to vote for it, but there are other provisions of law where $1,000 makes it a felony. I think that may be a good idea, maybe something to look at. But with that, Mr. Chair, I move for a favorable report to the PCS of House Bill 1070, unfavorable to the original, with a referral to appropriations, it looks like.
Heard the motion. All in favor? Aye. All opposed? No. Motion carries.
Thank you. Thank you.
Our next bill is Senate Bill 625. Representative Stevens. Is it a PCS?
Yes.
It is a PCS before the committee without objection.
Thank you, members. This is very different from the 625 that originally came. I will try to go through it briefly and see how we want to proceed. The first is some child welfare law reforms that a juvenile is supposed to be placed in a safe and permanent home within a year from the date of initially removing custody. It further defines abused juvenile under a couple of different statutes. It removes some statutory references, but still includes the entanglements. A neglected juvenile is going to be one where the parents or the caretaker, custodian is using illegal substances in violation of the law and is unable to care for and provide a safe and appropriate home for the juvenile, or uses illegal substances, abuses alcohol, or uses controlled substance while the child is in utero. Next, the juvenile is an infant who is born exposed to alcohol, illegal substance, or controlled substance, and if the parent's in or receiving counseling, then it will continue on, maintaining custody under a supervised type situation. If not, the child needs to be taken from that home. I'm going to try to go back to the analysis. I think it'll read faster. We've amended next of kin to adults that are located and notified of the out-of-home placement of the child, and the court will be required to consider developmental and attachment needs when determining whether placement with a relative is contrary to the best interest. Requires the court to include the developmental and attachment needs of a child when determining whether placement is appropriate. It includes a foster child as non-relative, foster parent as non-relative kin for consideration of a placement of a child who's resided in a foster home for at least 9 consecutive months, as long as the child is not a member of a state-recognized tribe and placement was not made with a relative. Clarifying unsupervised visitation does not have to be recommended or ordered before return of custody. Can be recommended or ordered. It amends the definition of review and permanency hearing. A review hearing would be held when custody has not been removed from a parent. A permanency planning would be when the child's already been removed. It amends the time period from within a reasonable time to within 1 year from the day of the initial order removing custody. It reduces the time a child can reside with an individual from 18 months to longer than 15 consecutive months to have standing to petition to terminate parental rights. It amends the standard of proof for adjudication from clear, cogent, and convincing to simply clear and convincing. Cogent was an unnecessary word. It amends the time a parent willfully leaves a child in foster care or other out-of-home placement from 12 months to 9 months without making reasonable progress under the circumstances which led to their removal. It talks about the RAMS program, which is very new and none of us have ever looked at. We've talked about suspending that for a period of time. There have been some violations already of the RAMS program that we consider inappropriate. The new section says it would create a private cause of action against DHHS if someone is harmed by a program that was administered, supervised, or funded by DHHS and did not go through rulemaking. did not have the specific statutory authority. It requires education and training for county social services boards. A lot of times they're just county workers and don't realize how important and that they should have some liability on it. Wanted to review again a child support tribunal study by the AOC. It sets up a conflict of interest procedure for county departments of social services. And it has an interim study committee to review child welfare programs, policies, and procedures, and review DHHS compliance with rulemaking requirements. A couple of these are bills that we've already passed from the House to the Senate, and we just put them in here to make it comprehensive. So I'll stand for any questions. I think you have comments.
Any questions from committee? Representative Moore?
Thank you. I think there's a lot in this bill that is not addressing some of the proactive things that we need to be doing to help families reunify and help parents who may have substance abuse or alcohol abuse to get them the services right away. We're shortening periods of time of ripping away biological kids from their natural parents from 12 months to 9 months. And we're even putting in the definition at the very beginning on the first page, the purpose of our child welfare reforms. It used to be reasonable amounts of time, and we're putting in the purpose of the statute, a 1 year from the date of the initial order. You know, my experience as a judge, oftentimes if we are referring a parent to get services, to get substance abuse, mental health services so they can be the best possible parent they can be, there's a wait list of 6, 8, 9 months. Because we're not funding appropriate mental health substance abuse services. And if this clock starts running from the date of the order and that mother or that parent can't even get into services within 8 months, there's no possibility of her meeting requirements and possibly losing her child. That's one issue that I'm really worried about. I don't see anything of services support money to support the children that need wraparound services, or to support the kinship placements or therapeutic foster families, which we have in this state. Where are we trying to be much more proactive than reactive, penalizing a biological parent and family? You know, these kids forever will look for their biological parents if we remove them even earlier than current statutes allow. I wish we would look at more of what we could do to help parents that need our help, to provide the services faster. But I think the way we're approaching it in Senate Bill 625 with these changes are more punitive. And I'm also worried about giving foster care non-relative kin placement. Foster care has a purpose of being foster care, and allowing them to suddenly step in as a party to the action, I think presents a real conflict from their role as foster parent to now interest in possible adoption and narrowing the time of terminating parental rights. So for those reasons, I can't support this bill. I hope it could be worked on. I know there's some things we need to do, but I think we need to put more resources into DHHS and not have a constrained knee-jerk approach. Thank you.
Would you like to reply?
Yes. Thank you for all the comments. It was certainly a lot, and I'll try to respond to all of them. One, this is not a budget bill. The things you're talking about, we continue to put money in the budget to help resolve those issues, to get more counseling, to get more things going. This is intended for those parents who are not doing anything to make improvement. As a matter of fact, that's what it says. Without making reasonable progress under the circumstances or correcting the conditions which led to the child's removal. The intent of these bills and the intent of the action we're taking is to give children, particularly young children, a home, not a system, a family, not a system. If you don't want to be a parent, you don't have an absolute right to continue to hold on to that child. You need to act consistent with your parental rights and responsibilities. So that's a part of what this is. Kinship. There is foster care parents frequently are doing that with the intent of adopting if that becomes the appropriate situation. One thing that we've been seeing is that frequently social workers have been yanking children from foster care without a reason. And that's very disruptive to a child too. If you listen to children, if you sit in criminal court, maybe you were never in Superior Court much, but we often hear those criminals in Superior Court talk about their abusive childhood. And that's what drove them to do what they were doing. They had no chance. They were abused. They needed stability. They were farmed out from home to home. And that's not what we need to continue to see happen.
Representative Bud, you recognize.
Thank you. I have significant concerns with the criminalization of pregnant women who engage in substance abuse or drinking alcohol while they're pregnant for a number of reasons. First and foremost, addiction is a disease, and the only reason that it's not covered by health, classified as a disease at this point is health insurance doesn't want to cover it. But criminalizing it doesn't change the fact that disease is addiction. It needs treatment, not criminalization. We don't criminalize cancer. We don't criminalize other diseases. This is the only one that tends to rise to the surface as something we need to punish people for having. That said, in addition, the American College of Obstetrics and Gynecology, which is the preeminent women's professional medical organization, has said that this is a very bad idea, because when a pregnant woman is confronted with the idea that she may not pass a drug test, that she will go to jail, she's not going to seek prenatal care. And that's a problem, not just for the mother, who's now not going to have support services on the healthcare level. It's a problem for the child, because now we're setting everyone up for failure. The risk of being born with neonatal abstinence syndrome skyrockets without any kind of treatment. It's entirely preventable if the pregnant mother receives treatment. The best way for her to receive treatment is to receive prenatal care that does not come with the risk of going to jail if she fails a drug test. So I feel like we, with this particular provision of the bill specifically, we are creating a class of children for whom the system is going to be the home, because we have set the mothers up for failure. We are not giving them the support services that are necessary and needed so that perhaps the mother can recover from the disease of addiction and become a good parent and involved with the child, but also giving the child the best healthy start to life. And so that this provision is just alarming for what it does to members of our community.
There is an exception for parents who are receiving treatment. If they are receiving treatment for their alcohol or substance abuse, we won't be removing the child and we won't be criminally charging them.
Follow up.
The problem is the fear that it creates in the pregnant mother that if she fails a drug test or a doctor has to report her for substance abuse, she will not only not report it, she will not seek the prenatal care, which again means that we've set them up for failure. We want them to receive prenatal care. We want these mothers to go see these doctors so that support services can begin. And the concern that I've got is that in the communities, that what is going to get out in terms of what these mothers learn is, if you are in trouble, you have a drug problem, you have an alcohol problem, and you're pregnant, don't go see a doctor because you might go to jail. And that's what they hear. That's not what the bill may say. So I understand the intent behind the bill, but the long-term impact on mothers and babies in the community, especially rural communities, the concern is they're not going to hear if you are making efforts. What they're going to hear is, oh my gosh, I could go to jail.
Well, hopefully what they hear is you need to take care of your baby. You've got a baby and that's your responsibility.
Representative Willis, you recognize.
Thank you, Mr. Chair. I've been in the preschool space for the last 12, 13 years, and we've dealt with a tremendous amount of foster children and families. We've seen a lot of really heartbreaking cases come back and forth, and I think what I'm hearing a lot here is about the mother and not so much about the child. And I think when we think about what's happening, and I think Representative Stevens mentioned, we've got some bills, some other things that are going to work on some of the proactive pieces. I mean, I'm all for increasing support and helping these children and providing the resources that they need to have the services that they need, because the children are never asked to be put in this position. They're put in this position, difficult circumstances, decisions made obviously beyond their control. And what we lose sight of is the yo-yo effect of these kids and the long-term impact. And so while as a parent of 3 children, I can only vaguely comprehend what it would be like to have them pulled away from me. You've also got children who at, 6 months, a year, 2, 4, 5 years old. I mean, this is, a year is 20% of their life. I mean, that's a significant portion of a young child's age for them to be yo-yoed back and forth. And you're talking about emotional stability. You're talking about long-term impacts of what these children are going to be dealing with. And we've lost sight of that in some of the arguments that have been made today. And, this may not be a perfect bill, but I do support the fact that these kids need to be placed in a stable environment more quickly. Our courts are backed up. We know there's some issues there need to be dealt with. And so maybe we can work with our courts and some additional funding or something that needs to happen to streamline and to fast track some of these. We've got parents who willfully want out of that relationship, do not want the responsibility. Why are we continuing to make it harder for them? We've got families who are willing and wanting to adopt and take these kids into loving, nurturing homes that are going to provide them with long-term stability and support. Why are we making it harder for that to happen? And so I think we need to look at everything that we can do. This is just a piece of the puzzle, but I ask for your support of this bill.
Thank you. Any further questions from the committee? If not, we have quite a few people that's, I'm sorry, Representative Butler.
I can't let that go unanswered. The last and worst result for a child is to be unnecessarily segregated from their natural parents. And everyone in that nuclear family needs to be given the full opportunity to rebuild that nurturing, loving, stable biological family first. Now, secondly, I don't do this type of work, but secondly, I can speak briefly to two things I do know. Having had family members who suffered from substance use addiction, the system is so difficult to navigate. I have a law degree. I've been a business person. I like to think I have some degree of smarts to get someone through a system like that. It is very difficult for people who are working hard and have the capacity even to pay for those services. I can't imagine how difficult it is if you face a backlog and you can't, and you're desperate to get the help you need, and you're unsophisticated or have no ability to navigate that system, first of all. And second of all, a backlog to get those services, even if you can pay for them. So that's terrible. And then secondly, having been a foster parent myself, I can tell you that there's no way in the world a foster parent should have any meaningful input except to say they love the child and they want to provide for the child in determining whether or not where the placement of that child is. There's an inherent conflict there. And so for a lot of reasons, I can't support the bill. I agree that I think your intentions are well placed, but I think the physical barriers that we faced on the ground are too much to put a 1-year time frame against.
Representative Budd.
I had one final comment in response to Representative Willis and some of the other comments today. And I understand the concern with the focus on the mothers when they are pregnant and there are substance abuse issues, and that we don't want to focus solely on them. But I will say, interfering with access to prenatal care by creating fear harms babies directly. A lack of prenatal care harms babies. And so when we don't provide support services and remove obstacles, we're not just harming mothers and interfering with an ability to seek treatment and perhaps and hopefully successfully complete treatment so that you can be the very best parent to that child. We're directly harming the child itself. And then we result in the system more likely becoming the home for the child, which is obviously the opposite effect intended by the bill.
Thank you. We have a list of speakers. The first one is Susan Osborne. Please state your name and your occupation, who you represent. You'll be allowed up to 2 minutes.
Thank you, Chairman. Susan Osborne, I'm Deputy Secretary at the Department of Health and Human Services. I'd first like to tell you that I'm a 30-year child welfare professional. I've been doing this a long time. And I want to start with the regional child abuse medical experts and our concerns. DHHS does not support this PCS. The Regional Child Welfare Medical Specialist Program focuses on our youngest children, children 0 to 3, who have been the allegation of abuse. These are children who can't tell us what happened to them. And this is a clinical tool that directly impacts safety of those youngest children. This is also a critical tool for our workforce. We have turned over child welfare workers in all counties at a rate of between 45 and 50%. As we turn those folks over, we lose experience, and that's what these regional child abuse medical experts give each county. Dr. Molly Burkhoff is here to speak today. She is a pediatrician in that program. And part of the Beacon child abuse team. Secondly, we are concerned about substance abuse in utero as a ground for removal. This will result in less women receiving prenatal care. It's happened in multiple other states. We have the facts and figures. This will significantly impact rural areas where services are not available. You invested last session in building that continuum. Give us a chance to use it. Thank you.
Thank you. Julie Cronin.
Thank you. Good morning. Julie Cronin, General Counsel, NCDHHS. Thank you for the opportunity to speak today. I want to echo Ms. Osborne's comments and highlight 2 additional points of concern that the department has with this bill. First, this PCS will present significant funding risks for our federal funds. Example, making reasonable efforts for reunification between parent and child is a federal standard and federal requirement. Shortening the termination of parental rights timeframe for when a child is removed from the home from 12 months down to 9 months will affect reasonable efforts due to court delays and lack of court time, which I think we have heard from some of the comments already today. Second, the private cause of action provision is an unprecedented infringement on sovereign immunity. The Tort Claims Act is the way in which our state offers limited waiver of sovereign immunity, and this proposed change sets a dangerous precedent and solely targets NCDHHS. Further, the Administrative Procedure Act provides an appropriate and adequate remedy for any individual who is aggrieved by an agency decision or wants to petition for rulemaking. Thank you.
Thank you, ma'am. Next is Tara Mueller.
Thank you, Mr. Chair, and good morning. Tara Mueller, Policy Attorney at Disability Rights, North Carolina. We are grateful to the sponsor for working to address the huge problems facing our children in our foster system. And I agree with Madam Chair that we want for all children a home and not a system, but we fear that this PCS will exacerbate existing problems instead of fixing them. North Carolina already has a severe shortage of placements for children, including children with disabilities. Last year, 15,000 North Carolina kids spent at least one day in foster care, and the length of stay was an average of 720 days, which was nearly 2 years. This signals just how difficult it is for us to find safe and appropriate placements. We have children living in DSS offices, hotel rooms, and emergency departments. Many of those children have disabilities. So yes, we must do something drastic to help these children, but our welfare system is backlogged and underfunded. So without making the actual changes that are needed, 9 months is not enough time and may end up harming children. We're also very concerned about the parts of the PCS that we've already heard today about alcohol and substance use of parents. Again, we worry that this PCS does not get to the root cause of the problems in our system and may end up making things worse. I would also like to read a statement today from Gail Osborne. She's the executive director of the Foster Family Alliance of North Carolina because she was unable to be here today. That organization says, research shows that children do best with their own families. As a foster parent, I want to know that every possibility for reunification with family is exhausted before I adopt a child in my care, whether it takes a year or even more. Yes, permanency should be a priority, but only if it's in the best interest of the child. The way our system is funded and operating right now, 9 months is too soon and even shorter than federal requirements. Please take a step back and hold off on making these drastic changes. We welcome the opportunity to work with sponsors on a collaborative solution, but we do not believe this PCS, as written, is in the best interest of our children. And again, that's from Foster Family Alliance of North Carolina, a statewide organization. Thank you.
Thank you. Tammy Fitzgerald.
Thank you, Mr. Chairman, and members of the committee for the opportunity to speak this morning. My name is Tammy Fitzgerald. I'm the Executive Director of North Carolina Values Coalition, and we would like to thank Chairman Stevens for her hard work on this bill. I know you've been working on the many issues in this bill for a number of years, and we think this PCS is a good bill. We support the bill, and if ultimately enacted, it will improve the lives of the children in our state, particularly those children who get stuck in the foster care system for years. So there are several provisions in the bill that we support that we believe will improve children's lives. This is primarily about the best interests of the children, and we should place their interests first. Between the ages of 0 and 3 is when the major attachments form in a child's life and when the most brain development occurs. And so what we are talking about here is trying to find a permanent home for these children while those attachments and that brain development is occurring. So first of all, we support the statutory requirement that a juvenile be placed in a permanent home within a year from the date of the initial order removing them from the home. Because a year in a 3-year-old's life is 1/3 of their life. We also support statutory language requiring the court to consider the developmental and attachment needs of the child when determining whether placement with a relative is consistent with the child's best interests. And third, when considering reunification, we believe statutory language requiring the court to consider in utero exposure to drugs and alcohol is very reasonable. Every child in this state deserves to be raised in a home with parents who can provide a loving and stable environment. This bill will help to achieve that end. Thank you for your hard work, Representative Stevens. We fully support the bill.
Thank you. Next is Jeff, and I cannot read the writing, Moret, I think.
Thank you, that's fine. Jeff Mayer, I'm Craven County Department of Social Service Director, and we had a chance to look over this bill. And there's just one matter that I'd like to state that the bill addresses. We've seen a sharp increase in Craven County with substance abuse affecting infants, and that's children testing positive for substances at birth. And we work with families with substance use, and what we try to do is that we do try to connect them to services, but at times when families are not engaging in those services, even when they're presented to them, we have a challenge sometimes meeting the legal definition now within juris environment. I would just ask that the statute look at that and see how we can, if we need to take that next step, not necessarily taking children into custody, but raising the level of how we work with families when we try to lesser interventions, when our social workers working with them outside of the court system, to see how we can do that. Not necessarily every child who tests positive for substance at birth needs to come into custody. We work with families in trying to, if they cannot reside with that parent in the home, trying to find an alternative placement who is a relative kin. And if we can't find an alternative placement through working with that family, that child may have to come into foster care. I would just ask for you to look at that section a little bit more and not make it such an automatic issue when there is substance abuse involved with young children. But I do think that it does need to be addressed. We're having a hard time meeting that legal threshold when we need to use it. And that's not when it's always need to be used. Sometimes we're able to work with families without having to go to the court system. But I will also say, as far as I am a member of the North Carolina Association of County Department of Social Services Directors, and we would we understand that child welfare is an issue that we all want to try to strengthen in this state, and we will be more than welcome to work with any of our legislators on trying to do that, no matter what political affiliation you have. This is a matter that affects all of us in North Carolina. We all believe that families are the backbone of our society, and that helps raise children and trying to get them in healthy environments, and what we can try to do that. I've heard a lot of good ideas today that we like to try and expound upon by all members. So I want to thank you for that and allowing me to speak.
Thank you. Adam Slope, I think that's how I'm reading this. Adam Slope,
Outside?
is he outside? Okay. Next, we have Molly Burkhoff.
Molly Burkhoff. I'm a pediatrician, a general and child abuse pediatrician, and I've been working in the field for over 20 years. I'm currently working with the Regional Abuse and Medical Specialist Program, the RAMS team that was mentioned in the bill. I think it's important for folks to understand that this team was created because there's no other team that works 24/7, 365 to support the work of our young workforce in child welfare. So if cases get stuck that are medically complex, there's nobody to ask. When we looked at the sample of 1,900 cases that we've worked on so far with the RAMS team, we've seen that the majority come from medical providers because we work, as Ms. Osborne said, with children predominantly younger than 3 years of age with injuries. When medical providers make reports, they are not specific in what they're calling in. For example, they will say things such as, I'm seeing a 2-month-old with a skull fracture. That's it. That will be accepted, and then a very young social worker is supposed to go out and understand, do I need to restrict access for this family to this child? Was this an accident? Is this a supervision issue? Or is this intentional harm that was created to this child? Without an expert team that can really help walk our very young workforce through these issues, we're at risk for either restricting somebody's access to their own child who should not be restricted. We've had cases reported with birthmarks that we do not want to restrict parents' access to their children when they don't have a bruise and it's in fact a birthmark. We also have cases where we need to make sure that safety plans are improved so that we can understand how to best keep this child safe during the CPS assessment, because there is a true concern for physical abuse. Without that team being able to provide that support 24/7, it's a very big loss for the counties. Additionally, I just want to say this is an experienced team of social workers that work on this team to support all 100 counties, and we've worked with 99 so far. This fiscal year, there have been over 1,300 consults completed, and the workers that we have on this team have all been supervisors in North Carolina from counties such as Buncombe, New Hanover, all across the state. Wake, small counties, large counties. So there really is very diverse experience in making sure they can also raise concerns up to the state, to DHHS, about policy that is challenging for counties to follow. Thank you.
Thank you, ma'am. Is there any further questions from the committee?
I'd like to make a
Representative Stevens.
Thank you. And members of the committee, I will tell you, it's been interesting to learn some about this RAMS program. I have a report of a RAMS medical specialist going out and overriding what the doctor said. The doctor said it was an accident, and the expert said, no, we're going to remove this from the home, regardless of what the doctor said. It says in statute they're not supposed to do it, but that's what they're doing. The other concern is, they created this, and you keep hearing the word policy. They aren't supposed to operate on policy. They're supposed to operate on statutes converted to rules, and they sort of refuse to do that. I'm going to ask if the chair will recognize staff to talk about what, in fact, the RAM specialist can do, which is little or nothing, I understand.
Division. So in looking at the CPS manual for the RAMS program, it was my understanding from reading it that the RAMS medical specialist could not provide medical advice, could not interpret medical records in the provision of the services to the local CPS. And so
Can they make recommendations?
They can make recommendations. And my understanding from the manuals, if the recommendations are in conflict with what the county social worker would recommend, then there would be an appeals process through a couple of different steps before a final decision was made of how to proceed with the family.
Thank you. Any further questions? Representative Morgan?
Is this down for comment or just?
Yes, ma'am. Recognized.
Second time. I have a problem with, we may have one story about a Rams investigate or a recommendation that may not have gone the way somebody wanted it. It seems like that's the way we legislate these days. We hear one story, let's change everything. I am very impressed by what I heard by Ms. Osborne, by Dr. Burkhoff. It's a clinical tool. I mean, if we didn't have the RAMS program, we'd probably be suing DSS for not having a RAMS program. It's like a child fatality task force. I mean, here's the problem. These are young people. Ms. Fitzgerald talked about the dire need to help these very young, these are 0 to 3-year-olds, that this is a specific program statewide of experts to help not provide medical records, not to give medical advice, but to look at the whole picture and a clinical tool for the case at hand, especially for new social workers that don't have the experience. To suspend this program makes no sense. Listening to the experts, listening to the experts on DHHS, we're in this bill a new civil action against a state agency. Where are we going with this? Isn't there some type of sovereign immunity? And then Mr. Merritt from local DSS, Craven County, his issue, and this is a big issue we really haven't addressed in the neglected juvenile, a new definition, someone who uses an illegal substance, abuses alcohol, or uses a controlled substance in violation of the law while the child is in utero. So what happens if a pregnant woman goes to her doctor, has a test, and tests positive for marijuana? Boom. She is now susceptible to be taken, have a petition in DSS as having a neglected juvenile because she smoked weed once. This is draconian. It's going too far. We need to rethink some of this. We do need to supplement our child welfare system, do better for all the children that are in need. But this PCS is not the way to do it. It's taking us backwards.
Thank you, Representative Smith. Oh, I'm sorry, Representative Butler.
Thank you, Mr. Chairman. Yeah, I just, I think about the people that I know who work at DHHS, the doctors, the pediatricians, the people who are foster parents who make up the Foster Family Alliance. And these are people that care the most about children. And we seem to be vilifying them. These are the professionals who know this better, far better than we do. So my concern, again, is that we have a goal, and it's a laudable goal, but the path to getting there seems very painful and punitive. And, people are casually saying things like, we want permanency, we want loving, stable homes for these children, and we're going to take them from the families that they're in, and we're going to find these permanent, stable, loving families. Where are they? We don't have enough people ready to fill those shoes in the first place. So, for a lot of reasons, this is a path forward that is too fast, too upsetting, and it's just ill-advised according to all the professionals. And I think we need to trust those people who have boots on the ground.
Representative Smith, you're recognized.
Thank you, Mr. Chair. God bless those fellow, the people that do this DSS on the streets. This is hard. And I know there's some disagreements in here, and I know part of the bill, I guess all of us agree on. There's parts that we disagree, but I think it needs to go forward, and we'll see where it heads. So with that, I move for a favorable report to the PCS of Senate Bill 625, unfavorable to the original, with a referral to House rules.
You've heard the motion. All in favor?
Aye.
Aye. All opposed?
No.
Motion carries. No further business coming before the committee. We're adjourned.